Weisbrod-Moore versus Cayuga County.
Good afternoon. May it please the court, I'm Jeff Herman from Herman Law with my co-counsel Mark Zotterer representing the appellant. I'd like to reserve 3 minutes for rebuttal.
Yes.
Thank you. We're asking the court to reverse and to reinstate this complaint. The Fourth Department erred by not applying and creating a special relationship from the custodial duty doctrine.
So are you asking for a separate standard for this special relationship, or are you arguing under the voluntary duty assumption under a regular rubric that this fits under that second step?
Right. We could get there both ways, but my main argument is that under the custodial relationship, that a special duty was created.
Okay, so under the voluntary assumption.
Could you really get there both ways? Because I'm not sure in the complaint, as a matter of the pleadings, whether you laid out the other one, the Cuffy type undertaking.
Well, I do believe we can get there both ways, but just to clarify, the main argument is not under Cuffy, the voluntary assumption. It's that because the parties were in a custodial relationship, because the county took custody of Jackie as a child, a special relationship was created.
So your argument and your focus is that the special relationship alone takes it outside of special duty, and you don't even have to deal with special duty. You can get there through special relationship?
Well, yes, just in the sense so that special duty is created because of the special relationship. It's very similar to...
Is that preserved below? Did you make that argument below?
Yes, we did. Yeah, and it was completely ignored, frankly, by the Fourth Department, not even a mention of it in the opinion. But we argued extensively that the Cuffy doesn't even, we don't even get to Cuffy, just like in previous cases with prison inmates, with
Can you
school
address
children.
on that front the difference? Your adversary, I think, rests fairly significantly on the distinction between physical and legal custody. So what should we make of that?
Yeah, it's a distinction without a difference. And that's because, as this court has held before, the reason there is a special duty in a relationship created in a custodial relationship is because the person in custody loses their ability to protect themselves. They must rely on the custodian, the government, to protect them. It's even more true when it's a child put in foster care. The child's parents' rights are terminated. The child necessarily relies on the county to protect them, to protect their interests. It's an
Sorry, go ahead.
If we were to agree with you, then what sort of evidence would you say would bear on the question of negligence?
Well, then it becomes a typical negligence case.
I understand, but specifically in this context,
Right.
what
Well,
would you
yes.
think would be fair game to
So
look
these
at?
cases, and in this case, the facts are that are alleged, is that this little girl was being sexually violated, raped, things stuck in her vagina.
But
and
it might well be the case in some set of circumstances that the state, the locality, would not have any reason to foresee that that would happen. And so what, in your view, would you have to prove in order to establish reasonable foreseeability in these kinds of circumstances?
Right. So in these kinds of cases, the evidence that typically comes in that's relevant is, for example, there's a duty to monitor the child, supervise the child, and make visits. If they don't do that, and they don't know the child's being molested and there's physical signs, then arguably that's negligence. There's cases where the child has told the county social worker, I'm being molested by the foster father, and the county ignores it. We have cases where that's documented in the files.
That's not this case, though, right?
Not this case.
Before you get too far afield, I just want to ask you, because I think what you said is once you accept the proposition that there's a special relationship by virtue of the custodial relationship, then it becomes, I think you said, a regular negligence case. And I was just wondering, because I read some language in cases like Ferreira, for example, that seems to say even if there is a special relationship that arises, the county would still be able to avail itself of an affirmative defense that it was acting in a discretionary governmental capacity. Would you agree that they could still raise that defense?
Absolutely. The government can still raise the defense would be that they were engaged in a discretionary action, not ministerial. And that they can avail themselves of that defense here as well. I don't think it flies, But they could raise that. It's an affirmative defense, which really isn't properly before this court, because this is a motion to dismiss. But the policy, which is very important, that the county is asking for is blanket immunity. What the county is saying is that any time a child is in foster care and they are negligent, which causes the child to be abused, they're immune. That would be a dangerous precedent.
Let me go back to something you said and something Judge Halligan asked, just so we can put a pin in it. I think you said that there's it's a distinction without a difference between physical custody and legal custody. And I'm wondering whether you would agree that the types of things that a state, government, whatever institution could be held liable for when physical custody is present might be different than when it's simple legal custody and physical custody is with someone else.
Well, and that gets to the negligence case.
That's right.
Because
That's what
we
I'm
still
asking.
have to prove, the plaintiffs also proved that the county was negligent, doing something that had, if they acted reasonably, would have prevented
that might be
the
a
abuse.
different universe of things if the county, for example, had physical custody of the child than if the county didn't.
Arguably, the facts would be different. But the county maintains legal custody even when they put a child in foster care, and it's considered to be a temporary placement. The county retains the right to have physical custody of the child. In fact, the county's duties require it, if the child is in danger, to physically remove that child.
But just to put a further pin in it, if we can, it seems to me, and perhaps this is what the chief is getting at, that in the context of physical custody, right, and you see this in the prison cases, the question is, and with the child, it might turn on safety issues, for example, has really to do with the interaction. Did the caregiver provide significant supervision such that the kid shouldn't have gone up the slide and jumped off the top, right? Or did the prison facility provide enough oversight so that fights were going to be identified and tamped down earlier? But when you're talking about negligence in a placement choice, isn't that a totally different set of questions that really have to do, as I thought you were getting at, with whether or not the choice to place the child in this particular spot with these particular people, whatever the due diligence is that has to be done under the statute and the regulations was complied with, whether complaints were ignored, those just seem like very different sets of questions to me. Would you agree?
Yeah, I mean, they're case specific. But the nature of acting reasonably, the concept is the same. So even in a prison case, just because an inmate's injured doesn't make the state liable. There has to be evidence that they were negligent. In fact, in the Flaherty case, which is the 1947 case applying this custodial doctrine, the state wasn't liable, even though they had custody, because it wasn't reasonably foreseeable that juvenile would have been injured. So it's case specific.
Right. But counsel, this might be the same question, but it's one thing to say that you were negligent in the selection of the foster parent, you were negligent in placing this child with this family. It's something else. It sounds almost like a kind of vicarious liability to say that the acts of the foster parent, negligent or intentionally harmful acts, are imputed to the county. Are you arguing that all of it comes under the umbrella?
No, and let me clarify this point, very important point. So we're not arguing for strict liability. We're not saying when a child, just because a child's injured in a foster home, the county is liable. What we're saying is only where we can prove the county was negligent in their, for example, in this case, their supervision of the foster child, would they be negligent?
So if the parent were if the parent were negligent but the county wasn't, no county liability.
That's correct. The only state that's adopted that, as I'm aware of, is New Orleans. But we're not arguing for vicarious liability. What we're arguing for is Louisiana, is specifically a negligent-based case.
You've tied, as I understand it, their responsibility to the duties given that they place a child in foster care. And that might vary, right?
Right,
Depending on the nature of the placement, depending on the needs of the child, depending on the information that the county has in advance and during the placement regarding the foster parents, right?
Right, the duties continue. They don't just drop the child off and say, oh, you know, we'll see this child hopefully when he's 18. No, they have a duty as legal custodian with responsibilities to monitor and ensure the safety. It makes no sense to say.
Is that a common law duty or a duty imposed by statute?
Statute. It's very specific. It requires them to visit the child monthly to ensure their safety. So,
But aren't you asking us really to make a policy decision that is best left to the other branches of government? I mean, Judge Smith and McLean talked about the crushing burden, the financial responsibilities of the city having, the municipality having to defend. For, I guess, the class of people now will be anyone under the age of 18 that's placed in a foster home, right? I mean, shouldn't maybe the legislature have some hearings, and there should be a more fulsome discussion before we expand the class of liability so dramatically?
I don't think we're expanding the class because of the custodial duty doctrine. This court has already adopted that principle. We're not arguing under McLean. I mean, on rebuttal, I will address the Cuffey duties very briefly, but this court has never applied the Cuffey factors to a custodial case. And that's because the court has accepted that when the government takes custody over an individual, depriving
So
them
are
of them.
you arguing here, regardless of the physical custody of the child, because the county had legal custody, the custody cases that have traditionally been applied should be applied here, irrespective of Cuffey?
Yes, and it's even more important here because it's a vulnerable child whose parents have been prohibited from being part of their safety net. The parents are not allowed, they're cut off, and the state says, parens patriae, we are stepping in as the parents for this child, and we have the duty to protect this child.
What's your point? Your point is legal versus physical custody, that what undergirds that view from this court is that the person who's in physical custody cannot care for themselves, right? There's some limitation on their ability to protect themselves that they would have otherwise been able to do, but that a child in foster care is unable to do that.
Yes, and I'll quote this court in the Pratt case, where it was a school case, where the court said, because the kid was dropped off at the school bus stop, the parents then had the obligation to reassume their protection of the child. That same principle applies here in the sense that the parents never have the right to reassume their protection of the child. This little girl is left at the mercy of the
Counsel,
county.
there seems to be a lot of emphasis on the state coming in and saying, you're unfit, the government comes in, we're taking this child now, we have responsibility. What if the state doesn't do that? What if it's an abandoned child, there are no parents? Is it a different rule then?
Well, we're talking about a custodian. I mean, the law requires, I think, the statute, if a child's abandoned, for the government to come in and take custody of them. But if
But they haven't come in and said, oh, no, you parents, you're not involved in this anymore.
then these principles don't apply.
So then that would not be a custodial liability case?
Correct. Now, there may be a way to get there under Cuffey. I don't know the facts, these theoretical facts, but I'm only saying.
I don't understand. Why is that not a custodial liability case? I thought this whole thing turned on the custody, right, that it's a legal custody. The foster parents may have physical custody, but that the county, as you point out, at any time could regain physical custody because it's got this continuing duty and obligation to oversee
Yes, but.
the foster placement.
Yeah, but I'm sorry, the fact pattern that I understood was presented was that custody was never taken.
No.
Well, but the
No,
question
that's
is what happens if custody isn't taken away from the parents? The child is found abandoned
Who has
somewhere, no one
custody
knows
in
who the
that
parent is, but the state assumes legal custody over the child.
Correct.
What happens
Well,
in that
once the-
circumstance?
Well, it doesn't happen, the state assumes legal custody and they leave them with the parents.
No. They don't know who the parents are. There's an abandoned baby at the doorstep, like in the Santa
Yes,
Claus movie.
then under social services law, the government does take custody of the child.
And so your rule would apply?
Yes.
So then it really doesn't matter at all that the state comes in and says to the parents, you're not fit, we're taking this child, because you seem to rely on that a lot, at least in terms of a high ground position. You, the state, are coming in and you're saying, you're unfit, we're taking over, you have no, I forget how you phrased it just now, but no ability to protect this child anymore. And I'm wondering if that's your entry into this custodial world, why that same logic would apply to the child abandoned that the state has
I
no
misunderstood your question. So yes, it would apply. As Justice Hand said, once the state acts, it has to act reasonably.
So the fact that they come in and take custody away from a parent is irrelevant.
Once they have custody, they're responsible to protect the child, reasonably. We're not saying it's, again, strict liability.
I thought your point was in part that whatever this duty is, there might be a different standard by which you'd measure this negligence if indeed there are parents who are also responsible that the child could turn to.
Is that right?
I'm sorry, so
Perhaps I misunderstood you.
yeah.
I thought in part your argument was the child is so vulnerable. Obviously, if a child is abandoned, there is no one other than the state and the foster parents, perhaps. I think that's the way you were arguing that. Maybe I'm wrong. But if the child has parents, that the parents cannot even intercede.
That's correct.
That was your argument.
That's a different standard of liability? The fact that you have parents who could intercede but now can't intercede, that's a different standard than the baby that's abandoned?
I thought your point was just that when a child, here we have an infant, I think, particularly, but when a child is in the state's custody, and therefore not in the custody of a parent or anybody else, that the child is unable to make any choices for themselves, obviously true here, and that's what, just like the prison context, gives rise to the special duty, regardless of how it came to be that the child is in the state's custody. Is that
Yes,
right?
yeah, and I'm not aware of any situation where the custody is split between the county and the parents. It's one way or the other. An abandoned child, if they're taken by the county, the parents have lost their rights.
I guess the bottom line is, does it make any difference to your standard whether the child was taken from parents or found abandoned?
No, and it's the same statute that applies, actually, that gives affirmative duties to protect the child.
Well, there are cases where the state has taken physical custody but not yet taken legal custody, right?
Well, I think in
Emergency removal where there hasn't been a determination that the child should be, that the parental rights should be terminated, right?
Yeah, I think, and there I mean, like a school case, they take physical custody of students for 6 hours a day, and then they give it back. And that's determinative on their responsibility when they have custody of the child. In that case, yes, they would.
Thank you.
Thank you.
Good afternoon. May it please the court. Matthew J. Larkin of Barclay Damon on behalf of the respondent, Cayuga County. I'm joined by my colleague David Fulvio today. Your Honors, what plaintiff appellant is arguing for today is for the court to create an ad hoc exception to the special duty rule. The precedent of this court...
Why don't the custody cases apply to this situation where we have a child that legal custody has been assumed by the government? Why is the child treated any differently than you would a person in a penal institution or a child at a school during the day?
Every one of those cases that are cited in briefs on both sides involved a setting where, for instance, their inmates are both in the legal and physical custody of the
Why does the
institution.
physical custody make a difference here? Do you agree that once the state, the county assumes legal custody, those foster parents don't have the right to make all decisions involving that child? They can't just take the child where they want. They can't keep the child forever. Why is there a difference? Because the state is not in physical custody.
The state gains legal custody through a court order, and under the statutory scheme of the social services law, has legal duties defined by statute. And this court has already determined that there isn't an actionable cause of action, a private right of action under the social services law. That was decided by the Mark G. decision.
But why is it different for this child
Right.
or any child in foster care, once the government takes custody of them, legal custody, They make all decisions. There is no one else, unlike in the Maldivin case. Why should this child be treated differently?
Because it's different facts, Your Honor. I don't agree, and I don't think the record, even though as small as it is, supports that there is no one else. There is somebody else. It's the foster parents. That's who is responsible.
So the legal custody, the physical custody trumps the legal custody of the county? Is that what you're saying?
What I'm saying is the legal custody defines the specific, or rather, the social services law defines the legal duties of the county, and
So the county could
physical
place a
well-being-
child anywhere?
No, of course not.
Without regard to whether they're appropriate or not, and not be responsible?
Absolutely not. There's requirements that are set forth in both statute and regulation that require the county to place the children with foster parents who've gone through training, that have been certified, that don't appear on the sex
Counsel, but
offender registry, things like that.
Isn't that the difference right there? Your adversary conceded to a question I asked, that we're not talking about vicarious liability. We're not holding the county responsible for whatever acts the foster parents undertook. The liability arises in the, screening of the foster parents, the placement, the failure to supervise the foster parents. So what does physical custody matter if the claimed wrongs are not arising out of the physical custody?
Well, the claimed wrongs that you just listed, Your Honor, arise out of the statutory obligations.
Yes, I know you might have a defense with respect to the statutory obligations, but that's what he's talking about.
But it's more than a defense. This court has already foreclosed that whole avenue of liability under Mark
So-
G.
But left open a common law-based liability.
It left open that for another day, and I guess today is the day, because it hasn't been
It
decided.
may very well
But-
be, so let's go there.
But the intervening precedent of this court on special duty really trumps that.
But this is a case, I think, that's presented as one about custody as opposed to the Cuffey factors. It seems to me under your rule, the rule that you want us to adopt, that no matter how reckless, forget negligent, the county might be, I'm not suggesting that that's true here, but in a hypothetical where the county ignores flagrant red flags, let's assume, for example, the potential foster parent has repeated convictions for child abuse, sexual assault, whatever it is. Let's suppose there are repeated and credible complaints to the agency about the conduct of the foster parent, that there would still be no avenue for liability. Do you agree with me that that would be the consequence of your rule?
Let me first say that there are no
I think it's
allegations
a
in
yes.
this complaint.
Of course, I appreciate that. I'm asking a hypothetical, though.
No, I don't agree with that.
So under what path could there be liability under the circumstances that I'm outlining?
By establishing a special duty under Cuffey.
Well, but I'm asking you if instead we treat this case as one where a special duty were to attach, if it attached as a function of custody, I take it you're saying that can never, that has no traction here at all, and the only avenue is through Cuffey?
I'm saying that's what this court's precedent says. That's
Well, so
what
how would you, what facts would you turn to under Cuffey if you were trying to fit it under one of the Cuffey factors in the hypothetical Judge Halligan gave you?
For this particular
No.
case?
Give me hypothetical facts that would let you meet that for,
if the-
for
if the-
a 2-year-old who's put into foster care.
Well, for a 2-year-old, I would imagine there would have to be somebody else who made some type of complaint or brought in some type of investigation, that there was some direct involvement with the child where they did some type of, oversight and review, in addition to what the statutory requirements are of just.
So if they just did what the statute required, then what? I mean,
Then.
How do you get to the point, how do you get to the point, I assume you're talking about the Cuffey factor, where you've taken some affirmative step to create a special relationship with the person, and you would say the statutory scheme is not enough to do that. So then what beyond the statutory scheme and the things required by the statutory scheme would you point to surmount the third Cuffey factor?
Well, I think that the statutory scheme is not shut down by my argument necessarily, but I believe it is under the Mark G. holding, that's just not enough by itself.
Right, so we don't
I
get
think there
liability
has-
that way, so we're all asking, so how do you get liability?
So I think, like I was saying, if there was a scenario where there was a report of some abuse, that it was investigated, that there was some reason for the county to know that the child was being abused and
But
then
does that really get
recklessly
you to
disregarded
cuffy?
that.
Because, I've racked my brain now for a few days trying to figure on the justifiable reliance prong of cuffy. How does an infant, I think we could all agree that there's no way an infant is going to justifiably rely on any representation. And I can't think of any third party who would be able, under the way we've articulated the cuffy requirements, who would fill the shoes of the infant in that, especially in a situation like this where there's been a termination of parental rights.
Well, I mean, if.
Basically, what I'm asking is, I think under cuffy, there can never be liability, there can never be a special duty in a case like this.
That may be the result, but that's not the argument, and I don't know that the court needs to go that far, because what I'm saying is that the special duty rule requires the plaintiff to make those allegations and prove them, and he hasn't.
But that's only if we agree with you, I think, that the sole applicable framework here is cuffy, and we don't agree with your adversary that the fact that the infant is in the custody of the county, as with Flaherty and the other custodial cases, is sufficient to give rise to a duty. And then the question is, was there negligence?
Well,
So why are we not in a, why is custody not sufficient here?
because in Flaherty and in Pratt and those other cases, you're dealing with more than legal custody. And
So
all
we
of
have
those
to
cases
agree with
we-
you that physical custody is required along with legal custody. Is that the nub of it?
Well, what I'm saying is, in those cases, that's the facts that the court
They are, but I
relied
think
on.
the rationale for the cases, and tell me if you have a different view, is that the individuals in those circumstances, because of the custodial setting, are unable to fend for themselves in a way that any of us otherwise would. And it seems to me probably, I think we'd agree, that an infant in this setting cannot fend for itself. And so I'm just trying to understand why, if that's correct, the same principle wouldn't apply, even though you're right, it's factually distinguishable in that there's not physical custody.
Because every one of those cases involved more, and they, for instance, in Flaherty, they talk about the fact the state would be liable for the institutions that it runs, such as schools and prisons and hospitals. It's more than just a pure governmental function like we have with DSS or the county in a foster care setting. Same with Pratt. The school wasn't liable because the child was no longer on their grounds,
Well, so how about Page v. State,
right?
where the child is sent to, the state is held liable and the child is sent to a privately run reformatory?
That the state, I
Yeah,
believe,
state was held liable.
if I have that case correctly, I believe that was a case where the state had custody and then used a state contractor where they sent them to the boarding school or whatever it was at the time, which is different than this type of setting.
Why
is
is that so? The government is responsible for the placement, has to vet foster parents, has to accept that it's a proper placement. Why aren't they an extension of government?
In the case that,
And again, at any point in time, the child could be removed from the foster parents.
right, the right to remove is different than actually having them in an institution that the county is running and that the county is staffing with county employees and where the county owns the physical property and is responsible for the safety of anybody who reasonably is there.
But maybe not very much different from an institution that is privately owned and privately run and has a contract. I mean, effectively, what's happened over time is there was an idea that children shouldn't be put in these reformatories and they should be deinstitutionalized. The foster care was a better setting. But the consequence of your argument is to say that that change, which was meant to benefit children, renders the state not liable because now they're using foster care instead of institutions. Even if the institutions were privately owned and privately run, there would have been liability, and now there's not.
There would be liability under this court's precedent if the state was actually owning and operating the
I think Page
institution.
is not owned and operated.
Right, but I believe that was one of the contract.
Right, and so why?
Where the state actually had the legal obligation for custody, both physical and legal, and they contracted out the physical part. Under the social services law, that's not what's happening here. The state, or the county rather, is taking legal custody and under the social services law, placing them into a foster home. And the difference between this setting and all of those other scenarios is there is a third party who's potentially liable. It's the foster parent. The foster
Yes,
parent.
liable for their particular conduct, and I think that's what Judge Canataro was pointing out, that the liability that they're arguing about is liability for the actions or the omissions of government.
Right, and to get there, they need to prove a special duty under this, the case law. Ferreira is quite clear. It says if it's a municipal liability based on a government function, they must plead and prove a special duty. And his position, plaintiff's position, is that they don't have to do that. It's not that they met it. The first time they argued that they met the duty was in their reply brief.
Right, his position is they don't have to do it because they have legal custody, which in
His position is-
Ferrer was not the case.
As I understand, his position is that there's a common law duty under foster care, which I don't believe there's a
Because-
single case that says that.
Isn't the difference, the special relationship takes place once they take legal custody? In general cases where people are seeking to sue a municipality, you have to first establish a relationship, because the government can't be responsible insurers of all. There has to be that special relationship. Isn't it different with a foster child versus the general public here?
It is different from the general public, but it's not different than any other child who falls under the foster care statutes that, what's alleged in this complaint, that the county assumed any duties beyond that. What they were required to do is to comply with the social services law, and nothing else. There's nothing alleged in the complaint or in any of the briefs that describes any common law duties that you would have, or the county would have to this child, other than what's required by statute.
So when you're reading special duty, special relationship, it's the same thing, so Cuffey is always the operative.
Well, it wouldn't be the situation if this child was placed in an institution that was run by the county itself or was contracted with the county, which is not what a foster home setting is under the statutes and the regulations. So this is different than all of those cases.
Would you agree that apart from the statutes, if government separates a child from their parents, takes custody, and then places that child with someone else, that they have a duty at a minimum to ensure that the placement is safe?
They have a duty under the social services law to put them in a safe setting.
I'm saying apart from that. You believe that if there was no such law, you say there, and government actually took a child and separated it from their parents and placed it in with a third party, that there would be no responsibility to ensure that that's a safe environment?
I suppose if they were acting outside the scope of their legal authority, they would have liability. But the only reason there's any relationship between this child and the county is the social services law. There's nothing beyond that. The county is not going into homes unauthorized and grabbing children. They were placed, the child was placed with them through a court proceeding under the social services law. I'm sorry.
No, it's okay. So, but just to be clear, because when I asked you before, didn't we have an open question after Mark G? You said maybe that's the question here, but really your position is not that it's an open question. Your position is we have answered that question in cases subsequent to that decision by saying there's only one path.
Right. I
Correct?
think that Mark G left the issue open.
Yes.
And I think that, Valdez, McLean, those cases say that if you're seeking
But
negligence case.
why send it back to replete if it's an open question? Why not, doesn't that suggest that the court was deciding there really is a common law claim? Let's see if you can plead it? Which is different
Oh,
from
you
saying
mean in
there's
Mark G?
no common law claim? Why send it back?
Well, Mark G involved basically an attempt at a class action suit.
Yes.
There's, constitutional claims, everything, and the court said they're all intertwined, and you couldn't decipher what was being alleged. I would think this court, even now today, all these years later, would come to a similar conclusion, that they shouldn't be deciding, the propriety of a pleading that hasn't been filed, that the procedural remedy.
But as a
would be
question of law, if the question is whether or not there's a common law duty, why wouldn't we answer that question? Why waste everyone's time and energy to send something back to be repled for a non-viable claim?
Well, because
You got to have a legal argument, right?
Well, I think the main issues in that appeal were already decided by the time they reached the common law tort liability issue, which is that there is no private right of action under the social services law, and there is no constitutional rights of action under the social services law. And I know I'm over time, but just one last point I wanted to make, which is that we talked about how a child could have justifiable reliance or an infant. These are sad situations, but they're no different than what you saw in Maldovan or Kersher, where a young lady was kidnapped.
But it is different from Maldovan. There was no custodial relationship.
Well, I meant it's different in the sense that in some factual scenarios, there can't be justifiable reliance because the child isn't able to communicate, but that's the only point I
But
was
she
making
had,
there.
in Maldovan, there was someone, there was a brother who
Right,
could act on her behalf.
right. And for
So
a,
the question is here, and it was left over in Maldovan, left open, what happens if there is no one who is capable of speaking for that child?
well, there are mandatory reporters, there's daycare people, there's, medical providers, there's schools that could act on behalf of a child. It's not that there's nobody in the grand scheme of things. This child, as alleged in this complaint, was put into a situation, if what they're saying is true, where they were in the hands of an abuser, but there's no allegation that was reported to the county. There's no allegation that they did an investigation and failed to act, or that it came in through some third party who was acting on their behalf. So it is different in that sense.
Thank you.
Thank you very much.
Good afternoon, Your Honors. May it please the Court, Philip Young here on behalf of the city as amicus curiae in support of Cayuga County. I want to directly go to a point that the Chief and Judge Halligan made early on. I think it's very important here to look at the difference between legal custody and physical custody. As Your Honor noted, in the physical custody context, what you have are classic common law duties of care. The child goes up the slide the wrong way, the parent doesn't exercise a duty of care in supervising that child. In the legal custody context, where there is no physical custody at all of these duties are prescribed by statute. They are in the social services law. There's a long, extensive list of obligations that the county or the municipality owes. The legal custody arises from Section 383, duties of care to place the child and do all of these things that are supposed to be done under the social services law.
Counsel, I'm sorry to interrupt, but during my brief and ignominious career as a family court judge, I gave out custody to many individuals, and in some cases I split quote-unquote legal custody and physical custody between two different individuals. But that's not the situation here. It's not as if a court gave physical custody of a child to the foster parents. It gave all the authority, all the decision-making authority to the state. And the state chose to place the child somewhere, which to me doesn't seem exactly the same as the kind of physical custody that I would award when that was a decision that I had to make. So I feel like you're sort of eliding the concept of possession and physical custody a little bit. Why is that not correct?
Well, because physical custody is quite different. It's all about control. It's about control of the space.
But nobody gave a foster parent physical custody of the child. No court of law there's no order I think you can show me in this case that says physical custody of child goes to foster parent A, right?
I don't know that there is a precise order, but generally when these removals happen, the legal custody is placed in the social services agency, and there's an understanding that the child will.
And then
be
the
placed
social
in
services agency gets to decide who's going to take care of the child, i.e. who the foster family is going to be. But that's not the same as custody to me. Or am I just sort of misunderstanding the very nature of custody?
No, I think physical custody is quite narrow, and it's the school context involving students, it's the prison context, it's the institutionalization context, and that is different from the legal custody context that we have here. Sure, when the social services district has physical custody of the child, it has common law obligations that it owes to that child. But once
Well,
it,
why isn't it different when foster parents, just because they have physical custody of the child or possession of the child, still don't have the ability to take actions in any manner in which they choose? I.e., they couldn't just leave the state with the child if they chose. With respect to the parameters of their care, they're dictated through the Department of Social Services, correct?
absolutely, they have some, certainly, authority over day-to-day obligations and things like that, but certainly on a more fundamental level, like, I think, issues about schooling and medical care and things like that are ultimately the obligation of the social services district, certainly, but those are obligations that are prescribed by statute.
So let me take you then from there to Judge Halligan's prior question. County says, let's place this child with a known child sex offender. It violates the statute, obviously, but there's no recourse directly under the statute, and your position is there's no recourse at all, I take it.
That's correct, Your Honor. There's recourse under the statute. There is a well-defined set of provisions that
No,
sets out.
but the child can't sue under the statute.
The child can't sue the
Nobody
social
can sue.
services district.
Right. And the foster parents are typically not very wealthy. And perhaps so the negligence of the county actually is not something for which the foster parents could be liable anyway, right? That is, and it's not negligent in this case, it's almost an intentional tort, but, right?
Well, certainly,
I don't mean, by this case, I don't mean this case, I mean my hypothetical.
certainly the child might have the ability to sue the foster parents depending on what types of injuries occurred.
No, I was asking something a little bit different. There might be negligence or recklessness or something like that on the part of the county, which is the decision to place the child in this foster care relationship in the first place. Whatever negligence the foster parents might have is not that. It's some other negligence, right?
Correct.
So there's no recourse, in your view, for the county's negligence in that circumstance.
There is no recourse for the county's negligence in the sense that the child does not have a right to bring a lawsuit in state
Can't sue
court.
under the statute, can't sue for tort, just out of luck.
And that's because there's a complex and complete statutory scheme
Well,
that
of
is
course,
set
there are
up.
places where negligence per se is based on the violation of a statute, no? In tort law?
Absolutely, but again, as Cayuga County noted, this court has been quite clear in Mark G. and then in McLean that the provisions of the social services law do not create a private cause of action, that the state legislature set up that system and provided for the enforcement mechanisms through fiscal
Are there
penalties.
failure to report under the social services law? Aren't those claims that could be brought?
Yes, under Section 420, there is a narrow claim that can be brought.
If there's
for-
notice of some kind of
Correct.
abuse and so on.
Correct, exactly. And this court noted that in Mark G., and it noted that the legislature chose where to put the private cause of action.
You argue in your brief that imposing liability here would be crushing on localities, and I understand the point that you're making, but what I'm wondering is this, given the posture here, obviously, I don't see that there would be any imposition of liability at this juncture were we to disagree with your position. That would have to be litigated, right? And so if we were to take the view that there was a special duty here, what kinds of proof do you think it would be reasonable to require to show reasonable foreseeability that might somehow address the liability risk that you're talking about? So, for example, I would think perhaps that if, as in my hypothetical, there were convictions that the foster parent had that were relevant to the conduct here, if there were repeated complaints, but can the liability risk you're concerned about be cabined by the kinds of proof that would be required for negligence?
I think it would be very difficult to cabin
Why is
liability
that?
in any way, because of, I think, if you look at the expansive scope of the type of complaint here that these plaintiffs are bringing forward, this is sort of every possible.
Well, this is on the pleading. I mean, though, in order to prevail on a negligence claim, right, presumably, one would have to show that there were facts that established that the harm was reasonably foreseeable. And so what I'm asking you is, particularly in light of the concern that you raise, what kinds of guidance or guidelines might be appropriate so that it would be clear? And I understand you disagree with the premise, right? But that what kind of guidance might ensure that there is only liability that is actually imposed and negligence that is actually found where the conduct warrants it?
I haven't thought deeply about that question, Your Honor. I mean, certainly it all turns on the question of foreseeability. And I think, certainly municipalities would argue that you need very specific and clear evidence that it was foreseeable that this particular foster parent would engage in this type of conduct. And certainly municipalities would try to defend on that basis, and municipalities will also try to raise governmental immunity as an affirmative defense, certainly. But I also want to point this court to the Westchester County's brief, which does a very good job of noting that in a lot of these cases, these things are being sent to trial very rapidly on almost no discovery, and allowing the jury to make a lot of inferences based on
That's
very
because
little
they're
evidence.
CVA cases? Are you talking about the CVA group or
My understanding is
anything
these are CVA cases, yes, Your Honor. And certainly, as we've noted in our brief, that there's over 600 lawsuits against the city that are going on right now. And, it's far different at the end of the day from some of the narrow cases like Maldivan or other cases like that this court has been dealing with. There's a clear, significant, and substantial impact on municipalities here that this court has over and over again recognized is an important factor when you are determining the scope of the special duty doctrine.
Thank you.
Thank you.
Thank you. The idea that just because there's statutory requirement or framework creating a custodial relationship doesn't preclude the right of a victim, of someone who's injured in a custodial relation from bringing suit. I mean, that's the situation we have with inmates. There is a very, strong statutory framework, the criminal justice system, that leads to people being put in prisons. The same thing with schools. There's a statutory framework. So just because there's a statutory framework doesn't preclude, in this case, a child from having a right to be able to bring a claim where there is negligence and they are abused.
The criminal justice system is available in this circumstance as well, correct?
Yes, I mean, there's no difference. I'm saying there's no real difference between a child losing their rights of protection in foster care or a child at school.
I thought your adversary's point, I'm sorry, maybe I misunderstood, was in those cases, there's physical custody. So it's a common law.
Well, he's saying.
But he's saying that in this case, where you have this statutory scheme, liability is governed not by the common law, but by the statutes, and we've said, no,
No, it doesn't preclude a common law right for negligence just because there's a statutory framework creating and ordering the custodial relationship. And this court has referenced in Pratt and some other cases.
But it's making a legal custodian relationship.
Correct.
Is that the difference? I mean, it's
There's
not
no
creating a physical custody relationship.
Yeah, there is no difference. And of course, when they pick the child up, they're physically picking the child up. When they place the child, the county drops the child off and has the right to take the child out.
So are you saying it's the equivalent of physical custody, or that legal custody alone is enough?
Legal custody in the situation alone is enough.
What do you say with respect to the argument about the crushing nature of having these suits on the public's fist?
Yeah, I would say that's not well-founded. First of all, there's not 600 foster care cases against the city of New York. He's including, I believe, school cases and other types of cases. So there, I believe, only 200 or 300 total under the CVA where the county or the government is the only defendant, because many of these cases have other defendants. And we're not opening up the floodgates to cases under strict liability. And we're also talking about the future. What the government is asking for here is blanket immunity in even all the extreme examples that your honors suggested. These extreme facts where kids were put into homes of known predators, et cetera. What the government is asking for, blanket immunity for the past and going forward, so that in New York, any foster child who's put in foster care and their rights are violated, there is no due care, there's even horrific things that the government knows happening, but they are going to be shielded from liability. You know, today is the day where I believe we have the right to stand up and the ability to protect our children in foster care, the most vulnerable population, you know, we can imagine in New York. And it would be unfair and not right to protect these children, not strict liability, but from negligence cases where the government fails to exercise reasonable care in the protection of children. And that's what we're asking this court to do, to protect these children in the past and in the future. It's not opening the floodgates. It's a reasonable expectation these children had, and the children should have tomorrow. The next child tomorrow who's put in foster care has the right to rely that the government is going to exercise reasonable care to protect them.
Thank you.
Thank you.